Brexit, Article 50, prorogation, and a Prime Minister slapped down by the highest court in the land. There's been a lot of talk recently about a constitutional crisis ever since that 2016 Brexit vote.
This is a constitutional crisis.
We are on the brink of a constitutional crisis.
This stretches the elastic of our constitution near to breaking point.
But wait a minute, what is our constitution and what does it even do? In this video, we're going to explain everything. From corrupt monarchs to beheaded ones, from feudal barons to members of parliament. Our constitution is ever evolving and it continues to change even today. And that's why Brexit is causing everyone such a headache. We're trying to untangle thousands of laws we got from the EU, while at the same time trying to not fall foul of our ancient and murky constitution. So will Brexit make us finally clear it all up? This is our guide to the UK Constitution, and whether it's time to write it all down. So how did we get here? Well, that's why I'm here in a field in the middle of nowhere. This is Runnymede, the birthplace of Magna Carta, where the seeds of British democracy were sown. The document sealed here in 1215 was an agreement between King John, considered a pretty awful monarch, and the feudal barons who wanted to stop him doing whatever he wanted. Magna Carta was the first time the powers of the king were in some ways defined and restricted. And it said that all of us had freedoms and rights under the law, and that the monarch was subject to the law as well.
No free man shall be seized or imprisoned or stripped of his rights or possessions, or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land.
Magna Carta laid the foundations for what was to come in the following centuries, namely the battle between the Crown and Parliament over who should really be in charge. That's what led to the English Civil War, the execution of Charles I, and the rule of Oliver Cromwell. But that was almost 400 years ago. What happened after that? And how did it lead to where we are today? That's why I've come to talk with the historian Matthew Smith, who's been researching the history of our democracy.
What you see is the incremental asserting of particularly parliamentary sovereignty. But I think the really interesting question is how that's taken place. Normally you would write a constitution after a major defeat in war or a revolution from below, something which would have swept away the authority of the previous government and the apparatus of state. We don't really see that. We see this incremental building of constitutional practice and understanding over time.
So while other countries around the world had these big crises and revolutions that led to them writing down their constitution, that never really happened here. Yes, parts of our constitution are written in law, but a lot of it is about history and what happened centuries in the past. It's that flexibility that some argue is the strength of our constitution. It can adapt and evolve, but others say it's just far too vague and it needs to be written down in one document. What do you think?
Right, so what makes up our constitution? Well, there are four main areas: common law, statute law, conventions, and works of authority. Let's start with statute law. That's legislation passed by the Houses of Parliament.
That is the ultimate source of our constitution, parliamentary sovereignty, that parliament is the supreme legal authority in our country. All that history we were talking about before was about asserting that very fact, that parliament is the key decision maker and not the crown. Basically, there is no law more powerful than an act of parliament.
Think about that famous recent decision by the Supreme Court that Boris Johnson acted unlawfully in suspending Parliament. In their ruling, the judges cited parliamentary sovereignty.
Parliament can make laws which everyone must obey. Prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions.
So Boris Johnson acted unconstitutionally by trying to stop Parliament having its say. Now that body, the Supreme Court, is also the highest court in the land and one that upholds another important aspect of our constitution, common law.
That's essentially a body of law decided on a case-by-case basis. Thousands of judgments handed down over the centuries by judges. Take murder, for example. Judges have always seen that as illegal. It didn't need an act of parliament to say so.
So many of our rules are protected by the common law as determined by judges. Again, this is part of the flexible nature of our constitution. Judges develop the law as they see fit, allowing old principles to alter to meet new, more modern needs. Of course, Parliament still remains supreme.
Now that's important when thinking about a written constitution. Take America, for example. The Supreme Court there can strike down any law from Congress by saying it doesn't follow the written US Constitution. Is that right, or should Parliament remain supreme?
But wait, what about the monarch? Doesn't the Queen still have some powers? This is where we come on to our third part of the Constitution, conventions. Now, the Queen is technically still in charge and retains some unique powers that are known as prerogative powers. But the majority of these have been given to the Prime Minister and the government. So, for example, while the Queen ultimately closes and opens Parliament, she only does so because the Prime Minister says so. Now, that passing of power from the monarch to the Prime Minister isn't written down in law. It's a constitutional convention. Basically, it's occurred naturally over centuries as Parliament has become ever more powerful. Now, some of these conventions are written down in a fourth body of our Constitution, works of authority.
Basically, books written by experts. And what's one of the most recent works of authority? It's this, the Cabinet Manual. And who better to understand this document than the man who wrote it?
The idea of the Cabinet Manual was, as it says on the tin, as it were, a manual for members of the Cabinet to understand their role in our complex democracy. For example, it tells ministers where their powers come from. All of those powers are subject to limits, and those limits are controlled by the courts. If everybody understood that better, we would be in a much better place.
In the last few years, we've seen the government taken to the Supreme Court on two big cases, Article 50 and prorogation. Could that have been avoided if they'd read the Cabinet Manual?
If they'd read the Cabinet Manual, they would have known that this was a risk. Because over my number of decades in the civil service, I have seen the number of judicial reviews of decisions made by government go up and up and up. I stress, this is not about Brexit as such. This was about the misuse of process.
Do you think our Constitution works as it is, or is it time for a change?
A written Constitution, no, because of the problems of it being written once and for all and being very hard to change once you've written it. I like the idea of having something which is dynamic. On the other hand, is everything perfect as it is now? No.
And that, of course, brings us on to the European Union and Brexit. Many opponents of the EU say it's taken power away from the UK and given it to Europe. Now, membership of the EU does mean European law is on top. If there's a conflict between UK law and European law, then European law prevails. But after the 2016 vote, we saw Parliament approve of Article 50 and start the process by which we can leave the EU entirely. So that shows that Parliament has always been sovereign. Hello, Alison.
Hi, Kieran. Lovely to meet you.
To chat a bit more about this topic, I've come to talk to Professor Alison Young, who's written about constitutional law in the aftermath of Brexit. Some people who voted Brexit say it was about sovereignty being taken away from Parliament and given to the EU. Is that right?
In some senses, I can understand where they're coming from, because when you look at EU laws, you have to comply with them. They override national laws. But that's not the full picture. We had a role in taking those decisions, so we're still exercising sovereignty that way. And if you look at what's happening now, this is Parliament exercising its sovereignty over how we leave.
Brexit seems so complicated. Is that partly because of our unwritten, vague constitution?
It's part of it, and I think that's shown some of the weaknesses, because we didn't necessarily have rules governing how we had referendums, when we had them, what the consequences were. But I think this is such a divisive issue that even with a written constitution, I think we'd still be seeing divisions, we'd still be seeing issues. A written constitution wouldn't solve everything.
One of the problems we have is that a lot of us just aren't taught or understand what our constitution is.
I think it's very worrying that we're not taught this in schools fully, that you don't necessarily fully understand how laws are made. Without that, with that lack of understanding, there can't be trust in the system, and for me that's crucial.
Now, what do you make of all of this? Do you think that our constitution works well, it's flexible and it can modernise? Or have all our recent troubles with Brexit shown that what we really need to do is write it all down?
There appears to be support for a change. According to polling from the Hansard Society, 72% of the public believe our system of governing needs quite a lot of change or a great deal of improvement. But what do the public want? When asked whether they agreed that Britain needed a strong leader who was willing to break the rules, 54% said we did. 23% said they were against that. 50% also said that it would be risky to give the government more power to deal directly with the country's problems. 42% said it would help if the government didn't have to worry so much about votes in Parliament.
So what are the arguments for and against a written constitution? I spoke to a former Supreme Court judge and a constitutional expert who are on different sides of the debate.
It is unwritten, which means it's uncertain, but it is also extremely flexible. This country has survived with its constitution not exactly unchanged, but more or less intact, through many crises that have washed away written constitutions in other countries. There is a constitutional crisis, but that is not because of defects in our constitution. It is because we have tried to insert a referendum into a fundamentally parliamentary system. Any constitution is vulnerable to people who want to trample over the basic values of the society which they're governing. In the world today, we can see two countries where this is happening. One is the United States, one is Great Britain. They are polar opposites in constitutional terms, and yet we are both suffering from exactly the same problem.
So, Professor, why are you in favour of a written constitution?
Our present constitution hasn't worked very well with Brexit. Should there be a supermajority if there was going to be huge constitutional change? What is the role of Parliament, given we have a representative democracy? How much easier it would have been if some of these provisions were simply clarified, if we had some sort of code. We have to sort those out, I think.
Isn't that the brilliance of our constitution, that it can mould and adapt and modernise as time goes on?
Yeah, and that has some great advantages. On the other hand, that also means that huge constitutional changes can be brought in very easily. Just imagine we had a majority government, even with just a majority of one, then it would be possible to do all sorts of things, and parliamentary sovereignty wouldn't look to be such a great concept then.
A common theme here is this: where do referendums sit in our constitution? Before 1997, we only had 4 in our history. We've now had double that in the last 20 years. Referendums basically take power away from Parliament and give it to you, the people. But Brexit was advisory. Technically, it wasn't a legally binding vote. So perhaps the real issue here is about the rules of referendums, about when and how they should be used. What do you think?
So that's our rough guide to your constitution. From Magna Carta to prorogation, we've tried to show you what our unwritten constitution is all about. How much did you know before? Has Brexit shown the weakness in our constitution? Or will it stand the test of time? Do you think we should have it all written down now? Do you, the people, want to have a say? And should we then decide on that constitution with a referendum? Is that the way out of this mess? Let us know in the comments below what you make of our historic, unique constitution, and whether it's time for a radical change.